Is it standard practice when there's no signs and there's no indication of what could have caused the death to take a jump to asphyxia? Is that what would be the common practice?
In my opinion, no. The way I practice and the way I've always taught people to practice in the institutions I've been associated with, again, we would call them undetermined. It's not, we do get cases where we don't find anything. We don't jump to conclusions or speculate. We just say these are things that might have happened. We don't know, so we're better left calling it undetermined.
We're turning our attention now to a case that also has a battle of forensic pathologist experts and whether or not a death was a natural death or one of murder. That was Dr. Catherine Raven. She's a forensic pathologist who took the stand as a defense witness in the case against Chad Daybell. He's the doomsday prophet turned accused killer, charged with the murders of his two children, the ones who belong to his second wife, but he's also accused of killing his first wife, Tammy Daybell. And we just heard Dr. Raven discussing her findings after examining the death of Tammy Daybell. Now, her conclusion for the manner of death was undetermined, meaning she couldn't confidently agree with the state's finding of homicide in this case. Well, today, the state recalled their own forensic pathologist as a rebuttal witness to refute Dr. Raven's opinion. Let's watch.
In her report, she'd reached a conclusion.
She did.
In your review of her report and just looking at what she looked at, if you hadn't had the additional information, would you have maybe reached her same conclusion?
Certainly possible, yes.
Toxicology tests were in fact conducted, correct?
Yes.
Based on those, did you find it likely that Tammy would have died of anything related to toxicology issues?
No.
Did you ultimately determine seizures was a likely cause of Tammy's death?
No, it was not a likely cause.
Given her age, medical records, and your review of everything, did you determine that a cardiac arrhythmia was a likely cause of death?
It was not.
And what did that leave you with?
That left asphyxial causes, essentially, at that point.
Are you aware, or did you learn that Tammy was taking an antidepressant?
Yes.
Did you see any signs or indication that the antidepressant played a role in her death?
No.
Did you see any sign or indication that sleep apnea may have played a role in her death?
No.
We talked about ultimately the cause of death being determined to be asphyxiation.
Yes.
When you are looking at the manner of death, how many potential manners do you consider?
There are generally 5. A death can be ruled for manner, can be ruled a natural death, an accident, a suicide, a homicide, or undetermined.
In this case, did you see any indication that led you to believe the asphyxiation was natural?
No.
Did you see any sign or indication that led you to believe the asphyxiation was accidental?
No.
Did you see any sign or indication to lead you to believe the death was suicide?
No.
So the 2 categories left would be homicide and undetermined, is that correct?
Yes.
Once you determined that the other 3 manners were not likely, that left you with which one?
Homicide or undetermined, but there was really nothing to compete with homicide, and so undetermined was taken off the table.
In your review of Dr. Raven's report and testimony and the questioning here today and through the trial, has your opinion as to the cause of death changed?
No.
Has your opinion as to the manner of death changed?
No.
And what did you determine the cause of death to be?
Asphyxia.
And the manner of death?
Homicide.
After this rebuttal witness for the state and a few more state witnesses, the prosecution officially rested their case. This happened earlier today out in Idaho, and this marked the end of 30 days of testimony heard by this jury. Closing arguments are set to begin tomorrow at 12 p.m. Eastern Time. There are 17 jurors who have been listening right now, but 12 of those are going to be the only ones who will be deciding the fate of Chad Daybell. And this jury is going to be sequestered throughout their deliberations. That could have a major impact on how things play out. For their thoughts on the state of this case, let's bring back in our think tank, still with us, and Bremner, Rick King, and Michael Sterling. Rick King, let me start with you. 30 days of trial. We've seen it all play out, and now they are at the end. It's the closing arguments for both of these sides in the case against Chad Daybell. If this jury does get hung up on anything in the deliberation room, what point do you think it's going to be?
Oh man, it's just what we just talked about. I was really compelled with Dr. Raven's testimony up until the point where they asked her, "Did you look at this?" And she said, "No." "Did you look at this?" She said, "No." "Did you look at this?" She said, "No." So, like those factors, when you factor those things in, I think might have a sway on the jury. But just her saying, "Hey, listen, here's the thing. I don't do the process of elimination at the very end. If I don't have any sure reason for homicide, I don't call it that." Now, whatever she did not review might come into play, but the best day for the defense is the jury is hung up on Dr. Raven.
Now, Michael Sterling, we've had 83 witnesses who have testified, and this is about the case for 3 different victims. Do you think there's a possibility there could be any kind of a split verdict where they believe that he was involved and some and not the other, or do you think it's going to be all or nothing?
A split verdict is always possible, Julia, because the only job of the defense is to get a juror to be able to articulate a reason to doubt. That's it, right? So you have to have a juror who says, "I can articulate a reason to doubt the state's case." And so that's what you have here is, basically the defense saying, "Let me give you a reason to articulate a doubt in that juror room." So I think it's totally possible you can have a split verdict where they say, "Okay, let's have a compromise. Let's say he wasn't guilty of this, he's guilty of this." So it's totally possible, Julia.
And the jury heard from him through these jail calls. They heard from him on these recordings, but they did not hear from him on the stand. He chose not to testify, which is his right. But do you think he should have, and could it have moved the needle one way or the other if he did take the stand?
I can't imagine him testifying. I mean, maybe it's me, but if he was my client, I would tie him to the chair. I mean, he can't get up there. I mean, there's so much about him that could elicit. Like, the kids are buried in your backyard, I mean, like that they go off to Hawaii, on your honeymoon, and your wife, dies in these circumstances, mysterious, and all these other problems. But I think the one thing, and I agree with Michael on this, I always agree with Michael and Rick, but I think they could split this also, because if he's got any chance of his family staying by him, which I understand they have. I mean, if the jury doubts would he really kill the mother of his children, would he really do that? I think that's what they're banking on here, because they're never going to win, I don't think, on the other counts. And I'm in Washington State. We're right next to Idaho. The last place you want to kill somebody out here is Idaho. I mean, the last. It's firing squad. The jurors are conservative. And so I guess that's the only, mercy that I think he can ask for here. And I don't know if he gets it.
Yeah, I agree with you that if the children and them testifying wasn't enough to help him avoid a conviction, then it may help him the most in the penalty phase. Let's take a look at some more of this rebuttal case from the state today. Detective David Stubbs with the Rexburg Police Department described some interesting data that he found during his investigation, including a user on a Gmail account that was linked to Chad Daybell, and it was requested to have location data deleted, several decades worth.
Do you recall testifying about serving warrants on Google in this case?
I do.
Did you receive Google records for an email account, chad.daybell@gmail.com?
Yes, I did.
In the body of that document, what do you see of interest to your investigation?
So this is what was of interest to me is the request to have deleted all location services. This was done, would have been 8/24 of 2019. Should be noted that the deletion range here goes back to 1970.
All right, I was trying to listen to hear a little bit closer. Rick King, real quick, your reaction to deleted data. This is how the state chose to end their case in chief. Your thoughts on just what that means when it's really the absence of evidence, not evidence itself.
I mean, it's ugly information to know that somebody went in and Googled how to delete information. But I think in the overall scheme of this, the fact that they went back to like how to delete since they deleted since 1970, that information seemed kind of weird to me. I don't know that kicks the can, over the goal line here. But I think that I mean, it's ugly information. Anytime anybody's deleting information, it comes off ugly.
It's certainly not helpful to the defense at all.